Welcome to this liquor licensing panel meeting on Tuesday, April the 1st, 2025. We start with item number 1 on the agenda. Are there any apologies for absence? I have none. Item 2, to receive declarations of interests from members in respect of any matter on the agenda. Do I have any? Right. The procedure the licensing panel will follow in considering the application is set out in the Licensing Act 2003, its attendant regulations, and was agreed by the Licensing Committee on 2nd of February 2005. The licensing panel, in accordance with Rule 14 of the Licensing Act 2003 Hearings, Regulations 2005, decide to exclude the public from all or part of the hearing where the licensing panel considers that it is in public interest to do so. Item number 3, to agree by general affirmation the minutes of the previous meeting held on 28th of January 2025 and to agree the minutes of the committee held on May 22nd, 2024. Do I have an agreement? Agreed. Thank you. Item number 4, application to review a premises license. I would like to remind everybody that individual names of the workers involved should not be used in the open hearing, as this hearing is open to the public and is being live streamed. This is to protect the identity of those people. If it is considered necessary for names to be used, advance warning should be given so that the panel can take advice and consider whether they need to go into private session for that section of the hearing. I would like to please ask the people who are present for this meeting to introduce themselves. If we could please go around the room. Thank you very much.
Good morning, I'm Lucy Corrie and I'm Assistant Director for Communities here at the Council.
I'm John Bryant, I'm the Licensing Team Leader.
I'm Sophie Mayer, I'm a Licensing Officer for Mid Sussex.
Chair, I'm Graham Hopkins and this is Linda Potter, my partner. We're from GT Licensing Consultants, representing the respondent.
I'm a license holder. My name is Darshan.
I'm Amy O'Riordan. I'm an immigration officer based at South East ICE.
Lisa Hunt, Licensing Officer for Sussex Police.
Good morning, PC Richard Jeffrey, Sussex Police, Police Alcohol Licensing Officer.
I'm Ginny Wood from Sussex Police Licensing.
Thank you.
Councillor Lee Farron and on the Licensing Committee.
Councillor Cavan Wood and on the Licensing Committee.
Okay, thank you very much. Well, we will begin this by hearing a report by Mr. Bryant, who is our Senior Licensing Officer. Thank you, Mr. Bryant.
Thank you, Chair. I just want to deal with one matter to start with. On the 28th of March, we received further information from the Immigration Enforcement Team in relation to this. I believe that Mr. Hopkins would want to make representations as to whether or not it will be admitted into this hearing. So if we deal with this point first, then I will go on to the main report.
Chair, the regulations are quite clear that new evidence should not be admitted after the end of the consultation period, which ended on the 10th of March 2025. We got this information and the council sent it to us as soon as possible. But my argument, my submission to you is it should not be considered. I haven't had time to talk to my client in depth about it, and it's outside the regulations, so we're asking you to disregard it.
Thank you, Mr. Hopkins. I'd like to refer to our legal advisor, please.
Thank you. Thank you, Chair. My legal view is that evidence is admitted up to the hearing, and even at the hearing stage, if all parties agree, and with the consent of the panel, the evidence will be admitted. This is found in Regulations 18 of the Licensing Act Hearings Regulations 2005, and I can just read it out to you so the panel is clear. So Regulation 18 says, just wait 1 second. In considering any representations or notice made by a party, the authority may take into account documentary or other information produced by a party in support of their application, representations or notices as applicable either before the hearing or with the consent of all the other parties at the hearing. So my view is that the evidence is admissible and should not be disregarded by this panel. Thank you, Chair.
Thank you very much. Is the panel agreed that we accept this latest evidence?
Agreed.
Thank you very much. Thank you, Mr. Hopkins. Okay. Now we proceed. Mr. Bryan, please.
Chair, thank you. The report in front of the panel this morning relates to an application to review a premises licence under the Licensing Act of 2003. The application has been submitted by the Home Office Immigration Enforcement Team to review the premises licence at RFC Chicken and Ribs in East Grinstead. The application, which is attached at Appendix 1, is made pursuant to Section 51 of the Licensing Act and is made by the Home Office Immigration Enforcement, a responsible authority, and the grounds for review relate to the licensing objectives of the prevention of crime and disorder. And the premises is namely RFC Chicken and Ribs, 22 Railway Approach, East Grinstead, RH19 1BP. Now, the application details 3 visits to the premises by enforcement officers from immigration between April 2023 and October 2024. And on all 3 visits, officers encountered individuals working at the premises who didn't hold the right to work. Sussex Police have also submitted a representation in support of this review application. Now, the panel must review the matter and determine the review on the evidence presented to it during the hearing, having due regard to the Licensing Act of 2003, the Mid-Sussex District Council Statement of Licensing Policy, and the Home Office guidance which is issued under Section 182 of the Licensing Act 2003. Now, the premises concerned, as stated, is in Railway Approach and is known as RFC Chicken and Ribs. It's a takeaway food business and has been licensed since June 2023 for the provision of late night refreshment for consumption off the premises only. Currently, at the time of the incidents referred within the review application, the premises licence holder who's present is Mr. Kumar Singham, and the current premises licence is attached in full Appendix 2. The premises is just licensed for the provision of late night refreshment on a Thursday, Friday and Saturday on the hours detailed on the report, but obviously the opening hours are far longer than just the late night refreshment hours. As stated, it operates as a takeaway food establishment in East Grinstead. There are photos of the store attached to Appendix 3, and the provision of hot food and drink between the hours of 2300 hours to 0500 hours every day is classed as a licensable activity of the provision of late night refreshment, and it can only be provided under the authority of a premises licence authorising this activity. Obviously, it's not a licensable activity to sell food and drink, hot food and drink outside these hours. There are a number of conditions currently attached to the licence in addition to the mandatory licence conditions. However, these conditions are not relevant to the substance of the review application, although they can be viewed in Appendix 2 with the premises licence. Home Office Immigration Enforcement have applied for a review of the premises licence, and they state they visited the premises up to when the review was submitted on 3 occasions between April 2023 and October 2024. On all 3 visits, officers encountered individuals working at the premises who didn't have the right to work there. The supporting evidence in full is attached to Appendix 4. Separate referrals were made to the Home Office Civil Penalty Compliance Team in relation to illegal working, and consequently a civil penalty notice for £30,000 was issued on the 17th of January 2024 to the licence holder. The penalty was due for payment on the 16th of February the same year, and the party had until the 15th of February to object to the penalty. No objection was received. Some payments have been made, the most recent payment being on the 4th of October last year. Immigration states that there's still just under £27,500 outstanding on that civil penalty. In addition, a further civil penalty notice for £60,000 was issued to the licence holder on the 19th of August last year. Penalty was due for payment on the 18th of September. The party had till the 17th of September to object. No objection has been received and no payment has been received for this civil penalty notice, and that remains outstanding in full. Now, the review papers outline that enforcement officers visited on 3 different occasions. On each occasion, as stated, illegal workers were found at the premises. On 2 occasions, all the people working at the premises held no right to work. One of the illegal workers was encountered on all 3 visits and another individual on 2. They say that this is a sign that the licence holder not only regularly employs illegal workers, but did not take any action following immigration enforcement's visits and warnings. They outlined that all the individuals encountered during their visits were witnessed by officers either working at the premises or attempting to flee as they visited. It's considered that the licence holder had employed them. They note the poor and dangerous conditions which they were living in and outlined that this is indicative of exploitative labour practices, and also cast serious doubt on the licence holder's credibility, as he stated to officers that he only let them live at the premises to help them. The licence holder refused to answer officers' questions or to provide information, and they state instead he showed a hostile and uncooperative behaviour. They outlined that it's expected that a responsible licence holder would cooperate with responsible authorities. The illegal workers all admitted to be given food and accommodation, and some admitted that this was in exchange for their labour. In addition, all the illegal workers admitted the employer did not request any documentation. Therefore, within their review application, the Immigration Service contend that the licence holder has showed in many ways a complete disregard for the UK immigration laws and demonstrated an unwillingness to improve his business practice. And they submit that for commercial reasons, those engaged in the management of the premises, employing an illegal worker and warning of this activity falling short of a review is inappropriate. Therefore, the immigration enforcement has proceeded to review the premises licence. They state in support that the premises are under his control. He's been found employing illegal workers. He's deliberately overlooked the rules and laws in place to prevent crime and disorder. And the licence holder would have been aware of their responsibilities to uphold the licensing objectives, as they are clearly part of the premises licence application. They state that merely remedying the existing situation, for instance, the imposition of additional conditions or a suspension, is insufficient to act as a deterrent to the licence holder and other premises licence holders from engaging in criminal activity by employing illegal workers and facilitating disqualified immigrants to work illegally. Therefore, their submission is that the premises licence is revoked, and their evidence is supplied to support their submission. In addition to their submission, as outlined earlier, on the 28th of March, the licensing department received further information from the Home Office Immigration Enforcement, asking to submit further additional evidence in respect of their representation. They stated on the 20th of March this year, immigration enforcement officers attended RFC Chicken and Ribs after receiving further intelligence that they were still employing illegal workers. During the course of the visit, one suspected illegal worker was found at the address. Following this, a civil penalty referral notice has been issued. Obviously, due to the short time since the visit, that hasn't been decided on. However, as this was the 4th visit in the last 3 years where suspected illegal workers were found, immigration officers served the owner of the premises, the licence holder, with a notice of intention to issue an illegal work enclosure order. On the 24th of March, Immigration Enforcement attended the address where they issued the illegal work enclosure order and closed the premises for 24 hours. Following this order, an application was made to Crawley Magistrates Court on the 25th of March, where an application for illegal working was heard before the magistrates. Following the hearing of all the evidence, the magistrates issued RFC Chicken and Ribs with an illegal working compliance order, which has effect for the period of 12 months. And as such, the Immigration Enforcement respectfully requests that the panel take this into consideration when they consider the information before them. Sussex Police have also submitted representations in support of the application to review the licence on the grounds of the prevention of crime and disorder. They detail that they're concerned to learn that on all 3 occasions that the premises has been visited, illegal staff have been discovered working. The immigration visit discovered workers being exploited whilst at work, and they are employed for long hours in exchange for squalid and unsafe living accommodation, and the wages being paid were far below the national minimum wage. The illegal workers who were discovered at the venue had all illegally entered the UK, with none of them claiming asylum or being granted permission to work in the UK. And they state that this highlights the premises licence holder has failed to manage the premises either by way of a deliberate act or by gross incompetence. And they further state that they support the request for the revocation of the premises licence. The agent for the licence holder has also contacted the licensing team prior to this review hearing and has offered a number of conditions that the licence holder would accept in order to prevent the licence being revoked for the consideration of the panel. I shall leave the details of those for the licensing agent to present to yourselves, as he may well want to expand on them further. Now, the policy context is Section 36 and Schedule 4 of the Immigration Act 2016 amended the Licensing Act 2003 to introduce immigration safeguards in respect of licensing applications. The intention was to prevent illegal working in premises licence for the sale of alcohol or late night refreshment. I've set out in the report section 52, which details the determination of the review and the legislation. And the licensing objectives are also set out at paragraph 28, which, to remind the panel, are the prevention of crime and disorder, the promotion of public safety, the prevention of a public nuisance, and the protection of children from harm. I know the panel are well acquainted with the Section 182 guidance issued under the Licensing Act, but I have highlighted a number of sections within the report for the panel's attention. Obviously, the 2003 Act provides a range of powers for the licensing authority, which it may exercise in determining a review where it considers them appropriate for the promotion of the licensing objectives. It further states that the licensing authority may decide that the review does not require it to take any further steps to promote the licensing objectives. In addition, there's nothing to prevent a licensing authority issuing an informal warning and the licence to the licence holder and to recommend improvement within a particular time. It is expected that the licensing authorities will regard such informal warnings as an important mechanism for ensuring that the licensing objectives are effectively promoted. However, the guidance goes on to state that where responsible authorities, such as the police or environmental health officers or the immigration service, have already issued warnings requiring improvement, either orally or in writing, that have failed as part of their own stepped approach to address concern, licensing authorities should not merely repeat that approach, but should take this into account when considering what further action is appropriate. Similarly, licensing authorities may take into account any civil immigration penalties which a licence holder has been required to pay for employing a legal worker. At 11.20, in deciding which of the powers to invoke, it is expected that licensing authorities should, as far as possible, seek to establish the cause or causes of the concerns. The remedial action should be taken should generally be directed at their causes and should always be no more than appropriate and proportionate response to address the causes of concern. In section 11.23, it talks about suspension of a licence and modification of conditions, and suspensions can take place up to 3 months. However, it does point out it will always be important that any detrimental financial impact that may result from a licensing authority's decision is appropriate and proportionate for the promotion of the licensing objectives and for the prevention of illegal working in the premises. Where premises have been found to be trading irresponsibly, the licensing authority should not hesitate, where appropriate to do so, to take tough action to tackle the problems at the premises, and where other measures are deemed insufficient, to revoke the licence. At 11.26, where the licensing authority is conducting a review on the grounds that the premises has been used for criminal purposes, its role is solely to determine what steps should be taken in connection with the premises licence for the promotion of the crime and prevention objective. It is important to recognise that certain criminal activity or associated problems may be taking place or have taken place despite the best efforts of the licence holder and staff working at the premises, despite full compliance with the conditions. In such conditions, the licensing authority is still empowered to take any appropriate steps to remedy the problems. The licensing authority's duty is to take steps with a view to the promotion of the licensing objectives and the prevention of illegal working in the interests of the wider community and not those of the individual licence holder. It goes on to state that there's certain criminal activity that may arise in connection with any licensed premises which should be treated particularly seriously. These are the use of the licensed premises for employing a person who is disqualified from work by reason of their immigration status in the UK. And finally, at 11.28, it's envisaged that the licensing authorities, the police, the Home Office, Immigration Enforcement and other law enforcement agencies, which are responsible authorities, will use the review procedures effectively to deter such activities and crime. Where reviews arise and the licensing authority determines that the crime prevention objective is being undermined through the premises being used to further crimes, it is expected that the revocation of the licence, even in the first instance, should be seriously considered. The panel will be required to give reasons for their decision. As stated, the appendices detailed. I don't propose to go through them individually for the panel, but the appendices are attached and detail the review application form from the Immigration Service, the current premises licence, photos of the premises, the redacted immigration supporting evidence, and the representation from the police. And that's the report before the panel this morning.
Thank you, Mr. Bryan. Now, I would like to invite Mr. Kumarasinghe and Mr. Hopkins to address questions to Mr. Bryan.
Thank you, Chair. We have no questions.
You have no questions?
Not for the licensing manager.
Thank you very much. Now, I would like to invite Home Office representative to direct questions to Mr. Bryan.
I personally don't have any questions for Mr. Bryan. He's quite comprehensively summed up a lot of my points as well.
Thank you very much. I would like to invite a police representative to address questions to Mr. Bryan.
We don't have any to address Mr. Bryan.
So I will now open it up to the panel. Councillor Farrett, any questions? Councillor Wood. Thank you very much. Thank you, Mr. Bryan. Obviously, a very comprehensive, complete report. Thank you very much. Now, I would like to invite the Home Office representative to make their application, please.
Thank you, Councillor. I would like to confirm that the committee members have first had time to read our submission pack. I can appreciate it is quite lengthy. And I don't propose to read through the full pack. but I would just like to make a couple of
Okay.
key points.
Excuse me, could you speak a little bit louder, please?
Of course.
Thank you.
Before I do summarise the case, obviously the case has been very well summarised by Mr. Bryant there, but I'll go over it from our perspective as well. The ability to work illegally in the United Kingdom is a key driver of illegal immigration. It encourages people to break the United Kingdom's immigration laws, and it provides the practical means for migrants to remain unlawfully in the UK. It encourages people to take risks in trying to enter the UK illegally by putting their lives in the hands of unscrupulous people smugglers and leaves them vulnerable to exploitative employers. Illegal working results in businesses that are not playing by the rules and undercutting legitimate businesses that are. It also negatively impacts on the wages of lawful workers and can be linked to other labour market abuse, such as tax evasion, breach of the national minimum wage, and exploitative working conditions. Working illegally is a criminal offence, and on conviction in England and Wales, an illegal worker may receive a custodial sentence of up to 6 months and an unlimited fine. Employing illegal workers undermines the licence objectives, specifically the prevention of crime and disorder. It's important to note that as immigration enforcement, we don't just drive around looking for businesses to target. We are an intelligence-led organisation, and there have to be significant concerns for us to action the incoming intelligence. We do not routinely refer to seek licence review, but we do so in selected cases where we have heightened concerns, and this is one of those. In this case, South East ICE have visited RFC Chicken and Ribs, if you're happy for me to mention the now 4th visit, on 4 occasions now between April of 2023 and March of 2025, encountering numerous people who were working illegally. So between those 4 occasions, there were 9 arrests made. Immigration enforcement received allegations of illegal workers being employed at the premise, and as a result, an enforcement team first visited on the 19th of April 2023. On arrival, 3 employees were encountered in the restaurant, and all 3 of these employees were subsequently arrested as immigration offenders. Without naming names, obviously, as the anonymity, the first worker encountered was discovered in a branded uniform within the kitchen. Home Office checks showed that the subject had entered the United Kingdom and made a claim within the Home Office. At the time of the visit, he held an outstanding claim allowing his right to be in the UK, however, he had no right to work. This was confirmed when he produced an identity document which clearly states no work under the specific recourse. He confirmed to immigration enforcement officers that he had been working at the takeaway and helping to prepare food and cooking, and he was given the job by the boss. It was also admitted that he did not show any documents to prove his right to work, nor was he asked for them. He also stated it was the licence holder who assigned his task and his work schedule. He stated that he didn't receive any payment for his work, but was instead given free food and accommodation in return for assisting in the kitchen. However, cash was found in his wallet, which suggests that he may have been receiving undisclosed earnings, further supporting the claim that he was being illegally employed at the premise. There was a second worker encountered on that visit. Home Office checks showed no trace of them legally entering the United Kingdom, nor of any application to regularise their stay, meaning they also had no work to be in or work in the United Kingdom. They were encountered behind the food service counter and engaging in food preparation. The subject denied working at the premise, but also stated that the boss would ask them to temporarily help behind the counter or preparing packaging food. For her help, she was provided with free food and on rare occasions a small amount of money when she needed it. This claim was countered when an interview was conducted with the third employee, who stated that the female was the manager of the shop and that she told the other gentleman when it was that he would need to work. There was a clear display of obligation and remuneration showing her employment there. The third worker encountered on the first visit, Home Office checks showed that in December of 2014, he was refused entry to the United Kingdom and then made a claim with the Home Office. At the time of the visit, his claims had been refused, so he had no right to be in the United Kingdom and no right to work. He stated that he had been working at the premise for a month. He did not receive any payment for his work, but free food and accommodation. He stated that he was hired by the licence holder, but encountered worker number 2 was the person in charge and telling him when to work. When questioned about pre-employment checks, he claimed that he was asked to show documents but didn't have them, and despite this, he was never asked to further provide them at a later date, but nor was he refused employment, indicating a clear failure to conduct any right-to-work checks by the employer. Immigration enforcement then visited on a second occasion on the 22nd of May 2024. Once again, officers encountered a total of 3 individuals within the premise, all of whom were immigration offenders. The first worker on this occasion was also the first worker from the previous visit, and no change had been made to his immigration status during this time. Once again, as he was still on the premise, showing that no lessons had been learnt from the initial visit, regardless of the civil penalty that had been issued. The second worker encountered on this occasion, Home Office checks revealed that he had illegally entered the United Kingdom and claimed protection. At the time of the visit, his application was still outstanding. However, his immigration bail specifies that he has no right to work in the United Kingdom. It also specified that he should have been residing at an address in Basingstoke, yet he was living at the restaurant premise. It's considered that he was working at the premise and attempted to flee, as he has no right to work in the United Kingdom and was aware of that. He denied working there, however did state he was living there, paying £150 per month. It is also worth noting that renting to those not allowed in the United Kingdom is also an offence. The third worker encountered on this occasion, checks show that he had entered the UK on a student visa, however never enrolled into his course. His visa had been curtailed on the 29th of February of 2024. At the time of the visit, he was an overstayer in the United Kingdom with no right to live or work. He was seen running from behind the counter and attempted to leave through the front of the restaurant. He admitted working at the restaurant for 3 months, stated there was no fixed shift pattern, but that his role was helping in the shop and cleaning. He confirmed that he was not paid a wage for his work, but instead provided with food and a place to stay at the premise. This arrangement once again suggests exploitative working conditions, as he was performing duties expected of paid employees without receiving any monetary compensation. When asked about pre-employment checks, he stated he was not aware if the employer knew his immigration status and right to work, but obviously the checks had not been undertaken. He had showed his documents to, in quotes, some boys who had taken photos. However, there was no undergoing of a formal verification process, which obviously is required. Immigration enforcement then visited again on a third occasion on the 2nd of October 2024. On this occasion, 3 individuals were encountered, 2 of whom were immigration offenders. The first worker was the first worker from the previous 2 visits, so we are now on 3 occasions, 3 arrests of the same person. So he has now seemingly been working at this takeaway for 1.5 years at this point, showing that no lessons have been learned, not only from the first visit, but now also the second. The second worker was, without using names, without making it confusing, the second worker on the third occasion was also the second worker from the second occasion. Once again, both still working at the takeaway, showing that no constructive action has been taken. Since then, on the 20th of March, we have visited again. The second worker noted on the second and third occasions was also arrested on the third visit. So that is now 4 visits with 9 arrests. 2 people were arrested on 3 occasions each. After the first visit, the business received a civil penalty notice for £30,000. A small payment was received on that, and £27,499.92 remains outstanding. After the second visit, a further civil penalty notice of £60,000 was issued. No objection was received to these penalties, and also no payment has received. That means the penalty remaining in total is £87,499.92 to be paid of civil penalty notices. It is also mentioned that after the visit on the 20th of March, Immigration Enforcement attended Crawley Magistrates Court, where an application for an illegal working compliance order was heard before a judge. They did issue the illegal working compliance order, and this order shall have effect for a 12-month period from the 25th of March. We feel it necessary to respectfully request that the premise licence for RFC Chicken and Ribs is revoked, as we do believe at this stage implying conditions clearly isn't enough of a deterrent given the continual and blatant disregard for the prevention of crime and disorder and any form of enforcement visit undertaken at this address. In section 182 guidance, at points 11.27, it outlines that certain criminal activity that may arise in connection with the licensed premise, which should be treated particularly seriously. This includes employing a person who is disqualified from that work by reason of their immigration status in the UK. Point 11.28 states that where a review arises from such activity and the licensing authority determines that the crime prevention objective is being undermined through the premise being used to further crimes, it is expected that revocation of the licence, even in the first instance, should be seriously considered. All of that being said, we recognise that our role is to bring these concerns to your attention as the local licensing authority. It's your area and it's you that answer to the electorate and represent the interest of the local people. In line with the guidance, the Home Office, specifically Immigration Enforcement, is seeking for the subcommittee to consider revoking the premise licence. Unless I can answer any specific questions, I don't propose that I take up any more of your time. Thank you.
Thank you very much. First of all, I'll go to Mr. Bryan. Have you any questions?
No, thank you, Chair.
Thank you. I invite the police representative to put forward any questions.
Yeah, just one question, please. The illegal worker compliance order, are there any conditions such can that be explained slightly better so that we have an understanding on what that imposes on the licence holder and any obligations that's imposed on that order, please?
Unfortunately, I don't have the order with me. However, it is a compliance order stating we will have a power to enter the premise every 3 months and check working conditions, employment checks, right to work checks, and these are all detailed that they must be recorded and kept on site. So ultimately, it is something that should already be being done. It is already expected of an employer. However, in a case like this where it's clearly not being adhered to, the illegal working compliance order now makes it a specific legal requirement where not following it is now a criminal offence.
Thank you. No further questions from the police.
Thank you. Mr. Hopkins, have you any questions?
I would like to answer.
Okay, thank you.
Yeah, hiya. I know I saw a few times on my property. Two of them, you know them, and they are asylum seekers. First time you visited, I've really accepted what the fine is, what I done it wrong. That's fine. I really accept. Sorry for that. But the main things, one of the guys totally mental health guy. You guys let him stay in my property. I was many times asked you guys, can you take away from these people to my property? You guys 4 times came to my property. Always you stay, okay, we're not taking, we had to stay here. So what is the reason? Because I'm is the same country fellow. I'm just helping as a homeless. That's all I did, right? I didn't give him any of them, right? 4 times, not 1 time, 2 times. Why you not taking to their? You guys had responsible for the asylum seeker to taken away from me. I'm just helping. That's it. One of the mental. 2 guys always 4 times. You saw them. Witness. That is a biggest. Because I can't really. Because one of your officers came to me, told me, why don't you kick him out? You was there as well. Using that words. I cannot say that. As a human being, how I'm going to use the words? As an immigration officer, he said to me, kick him out. Kick him out is assaulting. Thank you.
Yeah, I have been to your address on, I believe, 3 occasions now, personally. Unfortunately, from the immigration standpoint, it is not as simple as us just taking them with us. We have very strict gatekeeper restrictions in terms of who is detainable and non-detainable. With some of the gentlemen encountered on these occasions, they are undocumented. That makes things substantially harder for us. And following on from that, if they do still have pending applications with the Home Office, they're not detainable at all. We cannot just remove people from their accommodation willy-nilly because we fancy it. However, you have stated that you have allowed these people to stay within your property, and that is fine. I'm aware that you have the residential address upstairs, and I'm aware that's where they stay. You are allowed to let people stay in your house. That's entirely your judgment. So we can't just remove them from your address because we fancy it. That is not a lawful action. We can remove people from an address if we have the lawful right to detain them pending their removal from the country. The people with pending claims, we cannot remove them from the country. Therefore, we have no right to detain them and no right to remove them from an address. That would be an entirely unlawful action. I can appreciate I was there when my colleague did say, kick them out. That's a turn of phrase. He does not mean physically assault anyone. That is obviously not what he's saying, and you're aware of that. You're aware that what he meant was tell them they can't live here anymore. And I'm sure that you can appreciate that. The residential address is separate. If you want to have them living in your residential address, that's up to you. If that's something that you want to do out of the goodness of your heart for no money, that's fine. That's not a problem at all. However, the issue is that we are continually finding these people in the staff-only food preparation service areas of your business, okay? If they were found in a residential address, there wouldn't be an issue. However, finding them within your business, very clearly working there, is what is proving to be the issue at the moment. Yeah, I'm sure that you can appreciate that from our point of view.
Yeah, I'm really accept for that one. I apologize for that. That's why I got huge fine. It's like a homeless fine for me. It's £100,000. It's not easy to make for me. Even it's like I'm a homeless guy. It's £100,000. There's no way I can make this money.
I don't think you can say that.
No, just I'm saying to my words. But why I did accept it, the first one and second one, I accepted. But I apologize for that. I regret it now. So after the Magister Court, I react straight away, everything. I don't think it's going to happen. It's everything else, I moved out, all the record I have with me.
Yeah, I think you should say that when it's your turn to speak, okay?
Yeah, thank you.
Chair, sorry, I'm trying to wait for his turn to speak.
Okay, do Mr. Hopkins, have you any questions to address to Home Office? All right. Thank you very much. Now I'll open up to panel. Councillor Farron, any questions? Councillor Wood. I did have one question. When you address the illegal workers, to whom did they call boss?
The boss they were referring to was the licence holder.
It is the client who's here. Thank you very much. Okay. I think that's probably now we will go on. Police, your representation, if you'd like to present your case.
Good morning, committee and everyone. Sussex Police fully support this review application by the Home Office, who are seeking the verification of the premises licence, in particular the licensable activity of the supply of late-night refreshments. The review has been instigated due to the serious concerns regarding the employment of illegal staff at the premises. Sussex Police Licensing were disappointed to learn an enforcement visit discovered individuals employed at the premises who did not have the legal right to work in the UK. This is a clear violation of the immigration laws and raises significant concerns about the management and operation of the business. As a police licensing authority, our primary responsibility is to ensure the licensed premises operate within the law and maintain high standards of public safety and integrity. The employment of illegal workers not only undermines these standards, but also poses serious risks that directly conflict with the licensing objectives set out in the Licensing Act 2003. Prevention of crime and disorder. Employing legal workers is a criminal offence and contributes to disorder within the community. It undermines the efforts to prevent crime and maintain order, as these individuals may not have undergone necessary background checks, increasing the risk of criminal activities. Public safety. The employment of illegal workers can compromise public safety. These individuals may not have received proper training or health and safety instructions, which are crucial for ensuring the safety of customers and their staff. These, these negligence can lead to accidents and unsafe practices within the premises. The prevention of public nuisance, which illegal employment practices can lead to public nuisance issues such as overcrowding, noise disturbances, especially in the late night settings. The lack of proper staff management can result in uncontrolled behaviour and disturbances that affect the surrounding community. Protection of children from harm. The presence of illegal workers who have not been vetted can pose a risk to children who may visit the premises. Ensuring that all staff are legally employed and properly vetted is essential to safeguarding children from potential harm. We believe that a review is necessary to address these issues and determine whether RFC should continue to hold a licence. Our goal is to ensure that all licensed premises comply with legal requirements and contribute positively to the community. We have seen no remorse and no attempt to rectify the issue with a lack of payments and disregard to the visits and the authority. Prosecuted by civil fines at least 90,000, which is continuing to, with this continuing and not being paid. That is all.
Thank you.
Thank you.
Thank you very much. Thank you, much. I'll invite Mr. Bryan. Do you have any questions?
No, thank you, Chair.
I invite the Home Office representative. Any questions?
No questions, thank you, Chair.
So I'll go to Mr. Hopkins. Have you any questions?
No questions, Chair.
Thank you, Rams. Colonel Farron? Councillor, no questions. Thank you very much. All right, now I will invite Mr. Hopkins, if you represent your client, to present your case, please.
Thank you, Chair. If I just give you some brief background, that Mr. Kumarasingham has been at RFC since 2022, married with 2 children, and the business is their sole livelihood. He employs currently 3 people at the shop plus himself. 2 are full-time and 2 are part-time. We do have evidence that they have been checked. That's from the GovUK system, provided the gentleman's right to work details. Obviously, I'm not going to name them, but we do have those should you want to see them. I can also touch on that at this stage. There was a referral to the fire service for fire safety. Here we have a certificate from the fire officer withdrawing their concerns and stating that they are satisfied with the safety conditions at the restaurant. Mr. Kumarasingham accepts, Chair, that he has made serious mistakes. There's no doubt about that. When people were found to be working illegally on 4 occasions, he is very sorry for the mistakes, and I've spoken to him at length on that, and he is genuinely fully remorseful for the mistakes he's made. I would just explain to you in passing that, yes, the Immigration Service got a closure order last week. I spoke to Mr. Kumarasingham on Monday, and we arranged for him to try and get legal advice, but it was a bit short for us to short notice for us to be able to do that. But I understand the Magistrates Court imposed a 12-month compliance order requiring that Mr Kumarasinhan allows the Immigration Service to inspect his staff records every 3 months, and that was the outcome of it. They did not extend the closure order and close the shop down, so it is still allowed to trade. He has got the staff records and he is prepared for the officers to come and see them, in line with the magistrate's order. I would say as well at this stage that, like many other people that I've had to deal with immigration-led reviews in the old days brought by the local police and now by the immigration compliance team, there are a lot of people out there who still do not fully understand the rules behind the need to check. They know that perhaps that they've got to check that the people are here legally, but a lot of people do not understand the details of it. I've had to do research into it myself and find out because of the role we play, but I genuinely believe that he was telling me the truth, and that, well, certainly the first occasion, second occasion, he did not fully understand. He thought that if he provided food and accommodation, and a lot of employers do that, to people that were not actually being paid cash or online, a salary, that it was legal to employ them. So that is a mistake, and I think he fully understands now that you can't do that. It's as simple as that, and they've got to comply with the rules and their legal obligations. I believe personally that Mr Kumarasinhan is now fully aware of his legal obligations. He knows how to demonstrate it by getting these documents, that he knows now how to do a right to work check. That information is available to the officer if she wants to see it. And he will also be aware now that some people have leave to remain that can run out, and that needs to be, or their residence permit needs to be updated. He needs to keep a file on that and to bring that forward and check that. So he will be able to do that, and he will do it. We've covered the fire safety inspection. The question of the accommodation, I'm grateful to the lady for pointing out that if it's free accommodation, that is not part of this review, and we ask you not to take that into account. So he hasn't broken any rules on that. He's not renting it out as such. It's just accommodation for the staff, part of which Mr Kumarasinhan thought was perfectly legal. He now knows differently about the right to work check, etc. This review, Chair, as you'll be aware, is fully about promoting the 4 licensing objectives, nothing more and nothing less. I would say to you that any steps or outcome you decide on today must be appropriate and proportionate. Immigration are asking, and the police are supporting, revocation of the premises licence for RFC chicken and ribs. That would clearly lead to, or could clearly lead to, the shop becoming financially unviable, leading to closure and the 3 staff losing their jobs. That's not something I know you can consider, but we have to point out the obvious. Whilst it is your decision today to decide on the outcome, the sanction or the outcome that you've got to impose, I would now say that Mr Kumarasinhan is fully compliant. As I've said, he understands the rules, the legislation, and he has demonstrated that he has complied. Those documents are there should you want to see them. We would also ask you to remember that he is genuinely sorry for his shortcomings, fully remorseful, and that as an alternative to revocation, we have proposed a number of conditions that you could, should you choose, impose on the premises licence to ensure that the right to work check is enforceable under the Licensing Act 2003 and will further promote the prevention of crime and disorder objective. The conditions are actually based on some that were issued to us a month ago by the Home Office in respect of a review in North London. Obviously, I'm not going to name the premises, but they were accepted by the immigration officer on that. In fact, they were proposed by the immigration officer on that day. The steps are that all employees should have right to work checks completed. I'm sure you've seen them, but for the record, they have to have RTW checks completed before starting employment. Copies retained on site for inspection by the police, immigration or authorised council officers. Regular training to be undertaken for management staff on licensing and employment laws, including how to do the checks. It should take place on induction and be refreshed at 6 monthly intervals. Written training records to be kept for management and all records and staff, and all records produced to police, immigration or authorised officers should be kept for a minimum of 2 years from the date of completion. And for the first year after the review hearing, all training should be undertaken by a competent external trainer. That includes both on the Licensing Act and the right to work checks. Written training log to be maintained on site, detailing the dates of all training, topics covered, the names of the staff who have received it, again provided to officers for inspection, and they shall implement robust record keeping systems to track employee details, the hours worked, payments made, ensuring compliance with employment and tax legislation. The last condition is not strictly relevant to the right to work, but we thought we'd add it because people hanging around outside, etc. So those are the conditions we're proposing. In addition, we would submit to you that maybe a period of 2 months suspension while the training was carried out, the conditions were, soundly worked into their system, they set up their records, etc., would hit them enough to loss of the licence would hit them permanently. But this would bring it to Mr. Kumarasingham and his staff's attention. They've got to comply with these rules. Also, the fact that if they breach them under the Licensing Act could lead to a further review, revocation of their licence, and in fact, if they're prosecuted, could even lead to a prison sentence. We would ask you to seriously consider giving him another chance and to impose those conditions and a suspension period of up to 2 months. Thank you, Chair.
Thank you, Mr Hopkins. All right, I will invite Mr Bryan to address any questions.
Thank you, Chair. No questions.
I will invite Home Office representative to ask questions.
Thank you. Sorry, just a couple of questions on my part. Obviously, I'm aware that we're not discussing names and personal information regarding the right to work checks that you claim to have undertaken now. The question or concern for me is I don't believe those conditions to be sufficient given the severity of the issues that we have encountered. I fear that this may lead to a two-tiered staffing approach whereby those legally allowed to work will be checked for and accounted for. However, those illegally present may not be considered and included in the paperwork that you've decided to undertake. Is this going to become a situation where you only keep staffing records for those legally present and fail to run the checks or keep the records of those that you know are illegally present? I'd just be interested to see who those checks have been undertaken on, because I'd be fairly confident that the staff that we've encountered on 3 occasions each probably wouldn't be included in that.
Chair, I've just asked Mr Kumarasingham, as you've heard, he has checked all the staff that are currently employed at the premises. There will be no point in carrying out checks on people that are no longer working there. So the answer to the officer's question is yes, all staff will be covered. It would be an offence under the immigration rules not to. It's also an offence if those conditions are on the licence under the Licensing Act.
Thank you.
Might I add, it was an offence the first 4 times that those checks weren't conducted, not just now.
That's not a question.
No, but so that's the issue of it. I do also just need to briefly question the fact that you were saying the accommodation is entirely acceptable. In which capacity do you believe that to be the case? Because payment in kind is considered payment and is considered an acceptance of employment. So if that accommodation is provided on the basis that is remuneration for the work being undertaken, that is payment for the employment.
Mr Kumarasingham has just confirmed that the people that the officer is talking about that were there when they visited are no longer at the premises.
Thank you. Any more questions?
Thank you, that's everything for me.
Police representative, any questions?
Yes, thank you. I've a couple of things I'd like to address. The submission of proposed conditions for the committee to consider, should that be a decision they want to take. I'm also in agreement with my colleagues from the Home Office here that, that these proposed conditions are insufficient and that the first and second conditions are basic legal obligations that the premises licence holder should already abide to. The third condition is already sitting on top of the licence that's in place. The fourth one is also a legal requirement for the tax and employment legislation, and the fifth proposed one regarding the public nuisance is not why we're here today. Our main concerns, and why we're here today, support the revocation of licence, is to do with the late night side of things. This is when people who attend your premises will be at their most vulnerable. So as a question, please, these conditions do not offer up how you're going to reduce the vulnerability of people coming to your venue by having illegal staff there. So how can you give your guarantee and assurance as the premises licence holder that people in a vulnerable state, i.e. they're late at night, they're intoxicated, how are they going to be kept safe in your venue if your staff continue not to receive training that's pertinent to the Licensing Act? The staff training here does make no references at all to the licensing objectives. How can you keep them safe, please?
Well, I would argue, Chair, that there are conditions on the licence already. Essentially, the requirement to have CCTV, everything is, there's no suggestion it hasn't been used, it has been used, and so the police Home Office can check those, the footage for 31 days? For 31 days. The conditions we're talking about were proposed, another case I dealt with 3-4 weeks ago by the Home Office. So the officers saying they're no good, it's their own conditions. So we consider that they are an additional step that can be used. If he breaches them, he commits a criminal offence under the Licensing Act as well. So,
Thank you,
know,
thank you very much.
that's our position.
Thank you. Home
Thank you.
Office.
I do think it's entirely inappropriate to be presenting those conditions as though I've requested them specifically for this case. I fully understand what you're saying, that those have been proposed to you on a previous occasion. However, I think it is absolutely necessary to note that they have been presented clearly for a different premise. I don't know the premise you're speaking of. I don't know the enforcement activity or the action that was taken on that premise. I don't know the amount of times they visited that premise. I don't know the amount of offenders they've found. That is an entirely separate case with an entirely separate background that might not be anything like this situation that we are currently
No,
dealing
it's
in.
okay, excuse me. We allow the lady to finish, please.
Because I don't think it's fair or applicable that you're saying the Home Office suggested that, when that's an entirely separate occasion, occurrence, restaurant. There might have been a very different amount of offenders found. It might have only been on one instance. We don't know that. The councillors don't know that. No one else knows what that specific event was in relation to this specific event. So it's
Yes,
not
thank
really
you.
relevant in my
Thank
personal
you. I
opinion.
think we take on board that consideration. Thank you very much. Sorry.
I never at
Okay.
any stage suggested that the lady said it. I said the Home Office as
Yes,
a
sir.
body.
Yeah, you did, Mr. Right. No, okay. Now, excuse me, we won't enter in a debate at this stage. We take on board both considerations. Thank you very much. Police, have you ceased your discussion? I believe we,
Yeah, no further questions.
thank you very much. Okay, now, Councillor Farron, any questions?
No questions from me.
Councillor Wood?
No questions from me.
Well, as the panel, I would like to, if it's agreeable for us to be able to view the documents you've presented. You've presented something on fire safety, and you've also mentioned a couple of documents which we have not seen, if that were agreeable. Yeah, are Home Office and Police agreeable that we view these new documents, which we have not seen? Mr.
Chair,
Brown?
if I could, if there are documents which the panel are going to see, I think both the police and the Home Office should also be able to view them to make any comment on them as well.
Thank you. Okay, and we would do this when we sum up, okay. Well, I did have a question for your client, Mr. Hawkins. When you were first visited, the very first visit, and the Home Office talked about right to work checks. Did your client come to understand at that stage? So my question was, did your client come to understand at that stage a procedure which you would follow to find out that your workers had a right to work? Thank you.
Yeah, because this one, I'll be honestly, I didn't know before. Is my friend here. He teach me how to check it. Everything is behind me, and he showed me last week how do I check all the details, because these days everything is check-in online is completely different. I'm never had a knowledge about it, but he's explained to me, so now I know that how to check it, and what's the documents I need to first of all check. If I anything doubt, I can call the home office and then I can find out straight away. So I had a fully confirm. I can check straight away whoever anyone come to my property, passport, and online checks. It's few things, new things, but I've never had experience before. But I know now.
Oh, thank you very much. Thank you, sir. Thank you. I suppose my question was, Home Office visited 3 times before the 4th visit, and up to that time, you were not able to understand how to find out right to work for your employees. Okay. Yes, yes, Mr. Hopkins. Any- oh.
I think the gentleman here provided the training.
Okay, sorry. I think, yeah, I think we're not going to go there because we have the people here present who should be here, so no additions. Thank you very much. Right, well, I think if there are no more questions to be had.
Chair, I think we're just waiting for the documentation to be copied and returned.
Thank
I
you.
think that both the Home Office, the police, and myself as the licensing authority will need to view the documentation in case there are any questions resulting from it prior to your immigration actually summing up their matter and yourselves retiring. Because if you retire beforehand, you haven't had, the responsible authorities haven't had an opportunity to look and assess the information which is being provided to you.
I concur. Well, we could, yes, while with printing goes on, there'll be quite a few copies. Would it be appropriate to have a 5-minute adjournment?
Certainly, Chair.
Thank you. 5-minute journey, well, perhaps 10, Thank you very much. We will now commence having a copy of the documents that were submitted by of the client. All right, if I start with Mr. Bryan, if you would address any questions.
Thank you, Chair. My observations with regard to the documents are as follows. With regard to the documentation from the West Sussex Fire Brigade, that is in fact in relation to the accommodation underneath on the lower ground floor, and it isn't in respect of the actual premises itself, the shop premises. And it's in connection with the living conditions which were found by immigration during their first visits, which you will find on the photographs attached to their submissions. I think you need to bear that in mind, that that is totally separate to any issues surrounding the illegal working issues which are before the panel today, and relates to the fire safety and potential breaches of the Regulatory Reform Fire Safety Order of 2005. The fire service do confirm that that was complied with, and that's by removing the mattresses and the bunk beds which are in the lower ground floor accommodation. As I say, it's nothing to do with the subject of this particular review. Secondly, I'll move to the right to work documentation which has been provided. My observation is there's no dates on when the UK Gov right to work details were actually made. And I think that the panel need to bear in mind that on the visit on the 20th of March this year, which is less than 2 weeks ago, there was an illegal worker found working at the premises. So obviously I'll leave it for the licence holder to see how much, or to state how much you can rely on that. But there, I would point out there's no dates whatsoever as to when those checks were made. For all intents and purposes, they could have been made yesterday. And as I say, illegal workers were found at the premises 2 weeks ago, and I think the panel need to bear that in mind when considering this additional documentation. Thank you.
Thank you, Mr. Bryan. I will go to the Home Office if you would like to make any comments on the documents.
Yeah, just a couple of comments on the documents. It was stated that you have 4 employees, was it 2 full-time and 2 part-time, I believe? Within these documents, there are only 2 people that have had their right to work checked. So that still leaves another 2 unaccounted for, which does bring me back to my previous concerns about whether all employees were going to be subject to checks, or whether we were only going to acknowledge the checks of those who do have the right to work. Also worth noting, one of the employees here has been encountered, I believe, on 2 previous occasions at the address. So I personally do know that she works there. I have encountered her myself. However, one of the employees here that has been checked has never been encountered at the address across the nearly 2 years and the 4 visits that immigration enforcement have undertaken at the takeaway. We have never encountered one of these individuals working there. So as John has explained, it would appear to me that perhaps these checks might have been undertaken within the last 2 weeks.
Okay,
As
thank you. Thank you very much.
some kind of effort.
Thank you. Police, if you have any comments to make.
Just really to say that unfortunately our bundle is a sanitised bundle, so it doesn't contain any names of the workers there, so we're unable to cross-reference that. So we have no questions based on the fact that we cannot test the evidence that's been supported.
Okay, thank you. Thank you very much. Now, I'll open it up to our panel. Councillor Farron, have you any questions?
Yes, please.
Okay.
Just looking at 2 of the workers that are on here, one of them is addressed Hull, one of them addressed London. Do they live in your premises?
One of them she knows very well. I think she mentioned it. And the whole one, he moved out a couple of days ago. So he's gonna, near the East Grinstead, he's finding the, he's currently staying in my property right now, but he wanna find permanently in somewhere else near the East Grinstead area, but he's moved in my area now. So okay. It's not Hall, because he got uni, I think at campus or something. He's studying 3 days or 2 days or something. I think 3 days studying there, and then he's working part-time 20 hours with me. So
Okay,
he can find it out.
Okay, so he's studying in Hull,
Yeah.
working with you in East Grinstead.
Because he only 3 days only
Okay.
college,
How does he,
because he got an accommodation is in Hull. So when you go college, you stay there. When you finish college, you come back to my place.
okay, thank you.
okay, thank you.
Okay, thank you. Councillor Wood, any questions?
And
No, excuse. Okay, I'll just finish off with the panel and then I will come back to you. Yes, sir. All right, I think the panel have no questions. I think that's summing up. I think we, now the panel need to retire. Oh, I beg your pardon. Okay. Immigration, yes. If you'd like to sum up, please.
Thank you. Rightio. The Home Office does not wish to be involved in unnecessarily restricting genuine community services, such as successful pubs, restaurants or shops. However, there are very clearly concerns over the way that this business has been run, as discussed. There does need to be some remedy to that behaviour and a significant way of ensuring that it will not be repeated. This should also serve a clear message to other businesses who are fully compliant with the relevant legislation that satisfactory action has been taken. The relevant statutory guidance offers some suggestions, and your legal advisor will also be able to do so, and you may have your own views and concerns to consider. As described, given that 9 arrests have been made over 4 visits, and 2 of those offenders have been encountered 3 times each during those enforcement visits, there is strong evidence of illegal working being committed in relation to the premise. This has been sufficiently serious for immigration enforcement to issue a closure notice and for the Magistrates' Court to subsequently grant an illegal working compliance order. The Home Office, Immigration Enforcement have presented this evidence to inform the Licensing Committee's considerations and to draw its attention to the significant risk of the prevention of crime and disorder objective that is being undermined. In line with the guidance, the Home Office is seeking for the subcommittee to consider fully revoking the premise licence. It's requested that the Licensing Committee consider the premise licence and take the action that it considers necessary. Thank you.
Thank you very much. Right, Mr. Bryan, I believe you get the last opportunity to sum up. The client. Okay. Mr. Hopkins, you may respond.
Chair, I'll keep it brief. We're asking you still to not revoke the licence, to accept our client's made a mistake and he's sorrow and remorse, that he is trying to carry out what his checks and doing them, and that we feel the conditions and a suspension would be appropriate. Thank you, Chair.
Okay, thank you, Mr. Hopkins. Mr. Bryan, no summing up?
No, nothing further from myself, Chair.
Okay. All right, so I will ask our attendees to remain here while the panel retire and consider. Thank you very much. The representation submitted by Home Office and Mr. Hopkins last Friday, March 28, 2025, were accepted and considered by this panel. The documents submitted and accepted today do not relate to the matter being considered and could not be tested due to the late submission. Following careful consideration of the evidence, both orally and in writing, Section 182 guidance, the Licensing Act 23, the Licensing Act 23 hearings, regulations 2005, and Section 36 of and Schedule 4 of the Immigration Act 2016, the panel have decided to revoke the license granted for late night refreshment on Thursdays, Fridays, and Saturdays between 11 p.m. and 5 a.m. the following reasons. The panel considers that it is proportionate to revoke the license. The premises have been visited on 4 occasions, the last one having taken about 2 weeks ago, and on all those occasions, illegal workers and/or suspected illegal workers have been found on the premises. There have been 9 arrests, and living conditions have been extremely poor. In representations by Mr. Hopkins on behalf of Mr. Malkanasani, it was said that Mr. Kumarasani was under the mistaken belief that he could offer free accommodation and food and was not fully aware of his legal obligations, but that he does now know his full legal obligations and knows how to do a right-to-work check. Mr. Kumarasamy himself stated that he accepted he was wrong, at least on 2 of the occasions that the Home Office attended his property, and he accepted the fines on both occasions. Considering the seriousness of the issues, the vulnerability of the illegal workers, no requests for ID documentations, defrauding HMRC, not paying the minimum wages, civil penalties imposed by the Home Office, the panel is of the view that the crime and disorder licensing objective is clearly engaged. Because the licensing objectives are prescriptive and are concerned with the avoidance of harm in the future, the appropriate decision to make is to revoke the license. Also, the new provisions amended by Section 36 and of Schedule 4 to the Immigration Act 2016 prohibits licensing authorities from issuing premises licenses for provision of late-night refreshments to anyone who is illegally present in the UK or not permitted to carry out work in a licensable activity. Premises licenses granted on or after 6 April 2017 will lapse if a license holder's permission to be in the UK and work is time-limited and comes to an end. It would therefore be improper to allow premises license to be held by a person who continuously employs illegal immigrants. The panel also notes that the Magistrates' Court on 25 March, about a week ago, considering all the evidence before it on a criminal standard of proof, that is, beyond reasonable doubt, granted an illegal compliance order. This suggests to the panel that there were illegal workers at the premises at least on 20 March 2025 when the Home Office visited. The Licensing Act 2003 aims to promote 4 key objectives, which includes the prevention of crime and disorder. Employing illegal workers can be seen as a breach of these objectives, particularly the prevention of crime and disorder and public safety, as it can lead to exploitation and potentially criminal activities. On one of the visits from the Home Office, it is stated that there is no trace of one of the illegal workers found there before, Therefore, the Home Office is unable to know for certain the background and details of such a person. This is a concern of public safety. Thank you. Our legal advisor will.
Sorry, before you leave, just to confirm that additional notice will be sent out within the next 5 working days, and there's a right of appeal within 21 days. The relevant magistrates court is the Brighton Magistrates Court. Thank you, Chair.